Rules pertaining to claims and payment of benefits. When a life insurance policy matures or the life insured dies, a claimant must satisfy certain requirements for the insurer to pay the benefit. The claimant needs to provide satisfactory evidence that the life insured has died and prove their entitlement to the benefit. The agent's role in the claims process depends on the insurance companies involved, and no two claims processes are identical. An agent must be familiar with the claims process for different insurers to avoid a claim becoming contestable due to missing information from the application process. Claimant. The claimant can be the insured's estate, or one or more designated beneficiaries, whether primary or contingent. An assignee of the insurance policy or death benefit can also make a claim. In specific situations, a creditor might make a claim, and a court order may allow an individual to claim the benefit, for example, to cover spousal or child support. The insurer must ensure that benefits are paid to the correct estate or beneficiaries. In case of a dispute, the insurer may pay the benefit into court, which will be discussed in more detail later in this chapter. Insurer's records. Policyholders are encouraged to make a beneficiary designation and file it with their insurer. While a designation not filed with the insurer can still be valid against someone other than the insurer, an irrevocable designation must be filed to become irrevocable. Insurers pay benefits based on the most recent beneficiary designation they have on file, or to the estate if no designation exists. Insurers are protected by law when they do this, and are not liable if another designation exists that they were not aware of. Notice of claim. When the insured person dies, the insurer typically receives a notice of death from the agent, the estate executor or trustee, a beneficiary, or the employer. The insurer often depends on the agent to locate the beneficiary and assist them with the claim form. It can be difficult to find beneficiaries if there is little information about them, especially if the policyholder had little contact with the insurer and agent. The beneficiary may not even be aware of their status. If the insured person was also the policyholder, their family and executors might only discover the policy when going through the deceased's papers. In rare cases, the insurer that issued the policy may no longer be in business, and a search must be conducted to find which insurer took over its policies. The CLHIA is a useful resource in these situations. Upon receiving reliable notice of death, the insurer will record it to stop charging premiums and will wait for a claim. The insurer is not required to notify beneficiaries of the death, but it will contact the agent if the deceased used one. While a life insurance policy may have a time limit for making a claim, provincial and territorial insurance and limitation period legislation govern when a person can make a claim after the policy's deadline has passed. Courts may grant a beneficiary or executor some relief from these policy-based limits if it seems fair. In some jurisdictions, unclaimed benefits may be required to be remitted to the government. Proof of claim. The agent's role is important in proving a claim, as much of the information needed must match what the agent collected during the application process. Documents required. A beneficiary must complete a claim form, which they or the estate executor can get from the insurer. The insurer will assess the claim and pay the entitled person once it receives the completed form and required information. To satisfy the terms of a life policy, a claimant must provide proof of the life insured's death. The life insured's age, the claimant's right to receive the benefit, the claimant's name, age, and identity. Death is typically confirmed with a funeral director's declaration or a provincial death certificate. More evidence may be required if the death occurred under suspicious circumstances or in a country where proof of death is questionable. Probate. Insurers don't require probate in all cases, but they do require sufficient evidence of the party's right to receive payment. Proof of age. Proof of age is usually established during the application process. If the age was verified when the policy was issued or while the life insured was alive, the insurer will use the age on file without requiring additional proof at the time of claim. For term coverage, proof of age may be critical since the policy expires at a certain age. Proof of identity. For a named beneficiary, the insurer will require satisfactory proof of identity. Individuals with common names or those who have changed their name, e.g., after marriage, might need to provide additional documentation. When beneficiaries are described by relationship, e.g., children, or representative status, e.g., executor, they must provide additional documentary evidence, such as a court order. Accidental versus natural causes. Most life insurance policies have few limitations on the cause of death. However, if a policy has limitations, the insurer may investigate to determine if they apply. A common limitation is suicide. If a policy excludes death by suicide within a set period, often 2 years, of the policy being in force or reinstated, the insurer may need more detailed proof of death. Additional proof may also be needed if the policy has specific exclusions for activities like scuba diving or heli-skiing. Policies that only pay when death is caused by an accident are called accidental death policies. In these cases, the insurer needs proof that death was accidental and not excluded under the policy's terms. This may require a detailed physician statement, a coroner's autopsy, or a toxicology report. Policies that offer an additional benefit for accidental death typically require the death to be caused solely by violent, external, and accidental means. Courts have interpreted this phrase more broadly than just motor vehicle accidents or drowning. For example, the Ontario Court of Appeal ruled that a mosquito bite that led to a person becoming a paraplegic was considered an accident under an insurance policy. Disappearance and presumption of death. If an insured person disappears and remains missing for 7 years or more, interested parties, such as a beneficiary, can ask a court to declare them dead. This is often done to obtain life insurance proceeds. The timing of the death is important to ensure the policy was in force when the death occurred. Death of 2 or more people. When 2 or more people die, the sequence of deaths can be important for determining who is entitled to the insurance proceeds. For joint life insurance policies, the policy may specify who is presumed to have died first if the order cannot be proven. This also applies when determining if a beneficiary outlived the life insured. Payment into court. If an insurer has trouble determining who the beneficiaries are, even when a death is confirmed, provincial and territorial legislation allows the insurer to pay the benefit into court. This releases the insurer from liability and allows the court to resolve the conflicting claims. Payment into court may also be required by some provincial statutes to protect a minor's funds. Proceeds on deposit and payout options. Life insurance policies may offer several options for paying out a death benefit. These are called policy settlement options. The claim form may ask the beneficiary to select their preferred payment option. Agents are often involved in advising clients, but it is also common for the insurer to send a check directly to the estate lawyer, executor, or beneficiaries. The person receiving the benefit will have complete control over its disposition. This discussion on payout options does not apply to retirement products, which are subject to specific transfer or payout rules. Insurers must limit transfer options for locked-in retirement funds to those allowed by law, and agents should be aware of these limitations to guide clients effectively. The most common settlement option is a lump sum check issued to the beneficiary or estate executor, who can then deposit the funds at their preferred financial institution. Time to pay claim. Provincial and territorial insurance law obligates an insurer to pay a claim within 30 days of receiving evidence that satisfies that the claim is payable. While there is no legal entitlement to interest on an unpaid claim under the policy's terms, many insurers pay interest for a period between the death and the payment of the benefit. For a segregated fund IVIC, the death benefit is calculated after death and can fluctuate based on market performance. Denial of claim. As discussed in a previous chapter, an insurer may refuse to pay a death benefit claim for several reasons, in addition to the risk not being covered by the policy or an exclusion clause. These reasons include insurance fraud. Payment that would be contrary to public order. Lapse of the policy due to non-payment. A fourth reason could be that the claim was not made in a timely manner according to applicable provincial legislation, allowing the insurer to invoke the limitation period. Payment contrary to public order. When a beneficiary causes the death of the life insured, it is a violation of community standards or public order which allows the insurer to refuse payment. It does not matter if the beneficiary intended to benefit from the death or was even aware they were a beneficiary. The law entitles the insurer not to fulfill its obligations in such a case because it would be unfair to allow the wrongdoer to benefit. Accident and sickness claims. Accident and sickness policies have different benefits, which can be for accidental injury, dismemberment, death, disability, or critical illness. It can be difficult to submit a claim if the insured person is too injured to fill out the forms. To protect the insured, provincial and territorial laws provide relief for imperfect compliance with the claims process. AD&D claims. For accidental injury or dismemberment, the payment typically goes to the policyholder. For accidental death, payment usually goes to a named beneficiary or, if none, to the policyholder or their estate. Disability claims. Disability can be caused by an accident or illness, including mental or psychological conditions. Disability insurance is not unemployment insurance. The inability to find a job is not a relevant factor. A claimant must provide evidence to the insurer to prove they meet the definition of disability set out in the policy. This documentation must match the benefit requirements of the policy. The insurer will specify the required documents, which usually include a claimant statement and an attending physician statement, APS. The APS is used to determine when the policy's waiting period began. Critical illness claims. For a critical illness claim, a licensed physician must diagnose the insured with an illness covered by the policy. A lump sum benefit is generally paid 30 days after the claim is approved, and the policy then ceases. Segregated funds and annuities. When the life insured under an annuity contract dies, the beneficiary or estate is usually entitled to a death benefit, but this is not always the case. For example, if an immediate life annuity has no guarantee period or the period has expired, no death benefit is owed. Payout annuities can be purchased with a guarantee period, which means the insurer will continue payments even if the annuitant dies before a stipulated number of payments are made. Amounts accrued in an annuity or segregated funds for pension purposes are often locked in, and legislation imposes restrictions on their transfer. Death before retirement. If a pensioner with an eligible spouse dies, the benefits will be paid to the spouse, even if they were not the designated beneficiary. If there is no eligible spouse, the benefit is paid to the named beneficiary or, if none, to the pensioner's estate. Death after retirement. If the pensioner had an eligible spouse, the spouse may be entitled to a reduced survivor's death benefit. If there is no eligible spouse, a commuted lump sum is paid to the named beneficiary or the pensioner's estate.